This is Maria Calofian, a lawyer who handles criminal cases. Since people in her profession are not on the side of truth, but on the side of the client, here are several cases where the lawyer's cunning helped protect obviously guilty people. We will talk about the cases that Maria's colleagues conducted. The man was relaxing in a nightclub, drinking and using drugs. The vacation ended with him getting to the other man and brutally beating him for no reason. He was first taken to intensive care, and then he suffered serious health consequences. The aggressor himself was immediately detained and taken to the police station. He was wearing a t-shirt, and there were bloodstains on that t-shirt. And at that moment, the lawyer realized that this blood could belong not only to his client, but also to the person who had directly suffered bodily harm. If the preliminary investigation agency confiscates this t-shirt from us and conducts a biological examination, a certain connection, of course, immediately arises. That is, let's say we even discount the fact that the cameras weren't working at the time. There weren't any direct eyewitnesses to the crime, but there were bloodstains. So this is good evidence. And all this is happening right here on the first floor in the duty room. And it turns out that the door of the so-called monkey house itself is slightly open and only the bars are closed. And so they communicate with their client practically through this very lattice. The lawyer understands that there is some kind of incomprehensible fuss going on in the duty room. In general, everyone is rushing around. It seems like everyone is a little bit uninterested in him. And asks the senior duty officer, "Is it possible for us to change the young man's clothes? Because it's quite chilly. Let's put something on him." And he was all dirty, and there were also stains of earth and dust. Let's, in general, change his clothes. Senior, change your clothes and do whatever you want. At this point, the lawyer contacts the client's relatives. The relatives are already standing behind the fence, and they already have clothes with them. And so the lawyer runs out into the street, takes these clothes, changes his client's clothes, and understands that, yes, the evidence is now in the hands of the investigators. There is no specific evidence for this. What happened to the t-shirt? Washed with a t-shirt. Basically, they destroyed it and washed it. Well, in fact, what has already been washed has essentially destroyed the traces. But because of this, the lawyer puts himself in danger in this case. The moment when he tried to destroy the evidence himself. Well, where is he? Where will he write about this? Where will he say this? This is the first thing. Secondly, the t-shirt itself, the traces themselves have not yet been recognized as material evidence in the criminal case. No, there wasn't even a criminal case, come to that. That is, we simply had a young man who was allegedly suspected of causing bodily harm to someone. It was him, it wasn't him. This is also a very good question because the lawyer himself was not an eyewitness to the crime, therefore, yes. And what happened to this principal in the end? It turned out that he was not involved in committing this crime. His involvement, or rather, was not proven. Yes, that is to say, they eventually let him go. In any case, now he is free. In general, I believe that, in principle, human life is structured in such a way that you live your wonderful life, run, let's say, your own business, and at some point you can make a mistake. At some point you may stumble. And then, after that, you are a villain. If you caused bodily harm to someone, of course you did. Wrong. No one can just go and hit another person. There are people who are ready to admit their mistake, ready to admit their guilt, ready to compensate for the damage. And there are people who say that I wasn't there, I didn't see anything, I don't know anything, and this is my position, and he has every right to it. The burden of proof does not fall on the accused. The burden of proof lies with the preliminary investigation body. Therefore, in our case, we choose only the defensive position. The second thing, 2 scammers, a guy and a girl, rented an apartment in the center of Moscow. They lived there and sent phishing links to victims, gaining access to passwords and bank card details. They earned a lot. Suddenly, operatives from another region turned up to see them, as they had collected evidence of their involvement. The search begins, and at that moment, the lawyer knocks on the door. From this apartment, the door literally swings open, the clients appear, and two operatives appear. Well, the lawyer simply, just like that, probably completely brazenly says, "Your search was illegal. I don't care at all. You had an illegal search. Show me the warrant for this apartment to be searched." Okay, we'll show it. He shows him the warrant. He says, "Where's the seal? Why did you bring just a blank document?" The employees are completely perplexed. Apparently, they have never met such an impudent lawyer. And he starts calling the police. "I am a lawyer. Two unknown individuals in civilian clothes broke into the house of my clients. I don't know what they are doing there. And given that operatives always work in civilian clothes incompletely, ordinary clothes, it is naturally impossible to tell at first glance whether it is an officer or just an ordinary person." The police arrive. Imagine this picture. The door opens again, and police officers are standing on the threshold. Civilian police officers are in this apartment. Lawyers and his clients are in this apartment. There was also a cat there. Well, in general, there is a whole picture. Two operatives who arrived from another region are distracted by a conversation with police officers who arrived in response to a call. At this moment, the lawyer, he asks his doorman, "Where are your phones?" "Our phones were confiscated." "But there is nothing on the phones." "The phones were only, here's a personal note." "Did you work on a laptop?" "Yes, we worked on a laptop. It's over there on the couch." And it was literally about 5 feet away. A colleague told me he couldn't think of anything better to do than jump up to the laptop to the couch and realize there's a small gap between the couch and the floor. And the laptop is fairly thin and roughly sized, so he realizes he can squeeze it in there. He sits down on the couch, picks up the laptop, puts his feet up, and simply tosses the laptop in. Was he acting illegally? In this case, let's say you ask, I can say that the search was over after all. Perhaps they were distracted by the noise the lawyer made. And the lawyer, at the moment when the investigative actions were already completed, he took and hid this laptop. Everything, all the items that needed to be confiscated, and everything that was confiscated had already been confiscated. And this laptop, it just lay and rested on the sofa. Therefore, in fact, the lawyer had every right to put it, probably even in his briefcase, and take it away and pretend that it was his laptop, among other things. And how did the story end? The story ended with the young people being brought to the region, interrogated as witnesses, and released. All. Are there any moral restrictions in the profession? Well, let's say, you see, I won't take on this client. That's a very difficult question. Many colleagues are subject to condemnation from other colleagues due to the fact that they take on the defense and representation of the interests of, let's say, those same terrorists. What drives such lawyers? Firstly, a lawyer understands perfectly well that he is not obliged to feel great love or great sympathy for his client. There is no such provision. He must, let's say, in accordance with the law, if he is a state-appointed lawyer, especially one of the state, then he is obliged to appear, carry out the defense, carry out the very legality of the investigative actions, and leave. That is, the work must still actually be done. But there is another side to this. I actually had colleagues who represented the interests of a man who was accused of child molestation. First of all, we weren't talking about minors, we were talking about underage people. They were teenagers. And the teenagers, as far as I remember, didn't like the fact that the janitor, and the man worked as a janitor, made a remark to them. And teenagers, due to all their hormonal factors, they, of course, can behave noisily, or maybe even behave inappropriately somewhere. And the janitor decided to reprimand them, to say that, guys, you shouldn't make noise here, you need to behave decently. And instead of agreeing with, say, the janitor, the boys thought, why not tell the policeman that the janitor was making appropriate gestures that hinted at intimate intercourse, which was what was said. Next, I know that a lie detector test was conducted. The same polygraph was performed, which showed that the teenagers were misleading the investigator and everyone in general about the fact that they were not telling the truth. The man was in a pretrial detention center this whole time, and we probably shouldn't give him a lawyer. It's all very complicated. This is a very difficult question. I won't even try to judge everyone here and seat everyone in the corners. True, I won't take on such responsibility. Still, here I am. I will adhere to the opinion of our legislator. But was that man ultimately acquitted? Whom? Well, the janitor. No, they did not justify it. I don't know anymore. I simply stopped communicating with my colleagues then. They protected him. But I still know that this category of crimes is inevitable. Inevitably, yes, always yes. Therefore, I think men should stay away from playgrounds just in case, so that no one will. Say that someone was showing unambiguous gestures with their hands and feet and in general to everyone. Why is the percentage of acquittal agreements so low? And they say that it is a historically established fact that the judicial system in Russia has an accusatory bias, and that supposedly nothing can be done about it. It is believed so. Why exactly indictable ones? Because the representative of the investigation, that is, the investigator and the prosecutor himself, and these are all representatives of government agencies. The investigation has been going on for 12 months. The trial then continues for 12 months. In total, we have 2 years, despite all the work carried out, an acquittal is rendered. This may appear to indicate that the entire investigative body and the work of the prosecutor's office staff was carried out in an improper and inappropriate manner, which prevented a guilty verdict from being issued. Moreover, I will tell you that no investigator will pat himself on the head for an acquittal. That is, everyone will doubt that he can really do his job well. And it happens that the lawyer has extracted all the information from the client and ultimately passed it on to the investigation. Some lawyers may have had some friendly conversations with the investigator, and perhaps they did not even have any intention of harm. But here it's just elementary. There's such a word as good Russian balabolstvo when your tongue works ahead of your head. And this really hinders you in life. And in this case, it is nothing more and nothing less than idle talk. And I'm sure there was no evil intent there, but for some reason, everything was told. Perhaps the person has even already left and regretted what he said. Or maybe he didn't regret it, considering that he still goes around telling everyone what he's talking about. The third thing, the law enforcement officer was suspected of a serious crime. The discussion concerned information related to state secrets. A close friend of the suspect was involved in the case because his signature on the documents was the main lead in the investigation. A friend was invited to the department to provide samples of his handwriting for examination. And, of course, the client, close friend, and lawyer understood perfectly well that if they were now giving samples for research in a calm state, written on a piece of paper, of course, the research would show and confirm that everything that was written before and everything that they were trying to find out could all be revealed. But the most interesting thing is that, apart from this information, this body had absolutely nothing else. And a colleague having a lot of experience, in fact, good theoretical knowledge, and a colleague decides to do such a very risky thing. The lawyer says, I will show you and teach you what you need to do to ensure that the study does not show any compatibility, and the person trains for several weeks. After a few weeks, they meet in the office of an official, give a certain kind of samples, give them a certain position under a certain pressure by pressing. And it turns out that no questions arise for anyone, neither for a close friend, nor for the person himself, nor for anyone else. Here, well, there was a very big risk, because usually, according to the handwriting examination, and the examination itself, of course, shows, and it says in what percentage ratio and who could, to whom this or that text could belong by, which hand, right or left, it was written, for example. So it's quite difficult. And, in my opinion, of course, this is a huge risk. Well, if something were to come to light, what could be the consequences? Here probably, firstly, the person would still be held accountable for what was initially charged. Moreover, the person would also bear responsibility, perhaps the task of giving false testimony. But a lawyer, how can I tell you? A lawyer cannot come up with something and impose it on a client. A lawyer can support his client in one position or another. And given that a lawyer cannot be questioned as a witness in a case in which he is a defense attorney, how can one obtain any testimony from a lawyer? This is only, of course, if a case is initiated against a lawyer. But in this case, based on what? Speaking about you, how do you feel about risk? The situation may end differently. This is how my colleagues and I demonstrate that they can, it turns out, rip up your ID, throw you out, and call you all sorts of nice names. I mean, isn't that a risk? It's a risk. It's unpleasant. And when there is also, for example, I know that there is a video in the public domain where it is clearly visible that a person is hitting a lawyer who came to some organization. He is hitting him in the face. Is it a risk? Risk is also risk. Did the lawyer know that he could be hit? Perhaps I assumed. Now, if you are a criminal lawyer, most likely somewhere, of course, you still take a little risk because the issues you deal with are such they are very unique. Literally, the fate of people is being decided. The man parked his car at the entrance, completely blocking the passage. In the house, chat. The second man began to make claims against him. The traffic blocker didn't like these claims, so he decided to move the showdown from the messenger to the street. Considering that they have already brought in some third parties into this conflict, they have ended up with a serious showdown, as they say. And so, in the course of this showdown, one person, the one who initially didn't like the way his neighbor parked his car, inflicted bodily harm on another person, and the person who parked his car didn't lose his composure and also inflicted bodily harm in response. Well, as far as I understand, the bodily injuries that were inflicted in response were somewhat more severe. They weren't serious, they were just stronger, and the man somehow felt a little offended for himself. He files a complaint with the police, and a criminal case is opened. The person against whom the criminal case was initiated was told how. Firstly, he was kept in the department for a long time. And so, after they held him in that department, we said, "Now listen up. You'll need to return to that department tomorrow to give some more testimony, and don't even think about hiding, and we'll find you. We know where you live. We know your name." These were all police officers. He was scared, and that's why he tells the situation to the lawyer. Can you imagine? This is the situation they want something again. It seems like I gave some explanations, but they want something else. The lawyer asks him what you told them. Yes, we had a conflict. Yes, we covered each other, of course, with all the most possible compliments, but nothing more happened. That is, he completely rejected the fact that the fact itself existed. The lawyer understands his position, goes to the investigative bodies, and the investigator is sitting there. As it turns out, he is also the investigator in charge of this case. And he turns to her. It was a lady, as far as I know, although he does not yet have the right to get acquainted with the case materials. The investigator simply asks if I can look at the materials of the criminal case, just brazenly. The investigator himself is young and apparently does not yet have much experience and impudence, and he replies that yes, of course, he can familiarize himself with the case materials. And then the lawyer realizes that this is so good. Now he will know for sure. He starts leafing through the criminal case and realizes that there is a resolution to initiate a criminal case. Yes, there is a ruling recognizing the victim. Well, interrogation of the victim, fine, but there is no video recording, nothing. There are some statements from some bank, which, it turns out, show that someone transferred some money to someone else, and he understands that this is some kind of statement that was issued in the name of his principal. He immediately asks, "Did you provide any bank statements?" He says, "No. Tell me, please, how could the extracts have appeared there?" And the driver says, "You know, my dear lawyer, the thing is that the young man whom I allegedly inflicted bodily harm is an employee of one of the well-known banks, and he really did have administrative resources to obtain this information. There was information about money transfers. Perhaps they also tried to determine the circle of people from the money transfers. Who else was present then during the conflict? You. Remember, they also involved third parties, and so they tried to understand who was next to him then. After this, the lawyer appears at the inquiry again and says that, you know, guys, everything should be honest. In this case, I Know where you suddenly got some incomprehensible statement. I know who provided it to you. You will remind the victim that he had no right, firstly, to bring this, and you had no right to attach it. Since that conversation took place, nothing else has happened. No one bothered anyone. This, you know what this game is? It's the I'm waiting for you to make a mistake game. But imagine, here we are, the investigator, me, both of us, and most likely only we who have a law degree. But we most likely have different backgrounds in theoretical and practical knowledge, and it's as if we're in the middle of a little procedural war, let's call it that. And of course, I'm waiting for the investigator to make a mistake, and he does.